Licensing plant patents. So first, is licensing a plant patent any different from a conventional patent licensing? Plant licenses have slight variations that we need to take into account. For example, plant licenses relate to replicable material. That means you must put it in the field. There's no resale of the original seed, a sale of next generation seed for consumption as food or feed only. And also, there's a single plant only, no saving or reselling of the seed. So what use of materials are permitted in plant patents? That's a question that you need to address in the license. Another question to address in the plant license is what use of materials are permitted. Also, what kind of research and development and field trials are to be taken before commercialization? The license agreement must address or should state that there shall be no reverse engineering, no research, no molecular markers, and no breeding of the seeds. Who are the potential licensee for a patent? So first is the seed company. It's a vertical licensing arrangement with sub-licensing rights. There's also wholesale retailers who would resell the seeds. There are also food ingredient suppliers who may be interested in licensing the plant patent. And there's also certified seed producers or nurseries, as well as exporters. Those are potential licensees of the plant patent. So what are the range of options? Of course, licensing is where we prefer to make the patent available to third parties, and the opposite side of that is litigation or enforcement against third parties. In an enforcement action, you will see increased damages and you can get injunctive relief. But the downside of that is that there's a cost of litigation, including monetary, and possibly the industry may also think of the patent owner as in negative terms, such as one term might be trolling. So somewhere in between the litigation and the licensing is where you want to be. You need some litigation to tell the potential licensees that there will be downside implications if they don't negotiate in good faith. But on the other hand, litigation has its cost and downsides, and so you prefer not to litigate. You prefer to take licenses if people are willing to pay for the research that the patent owner has done. So what are some potential license structures? First, there's right and obligations specific to plant licenses, and there's also boilerplate clauses. In a typical license structure, what you have is the exclusivity term. Is it exclusive license or non-exclusive? You also talk about the territories. Is this US only? Is it in a particular state, California? Or is it in, let's say, Mexico? Or is it global? So you need to discuss a territory. The license should also allow the licensor access to the facilities for inspections and for sampling. There should also be reporting requirements, such as at least an annual reporting requirement of the royalties due, if not perhaps a quarterly requirement. There should also be marking requirements on the seed or any subsequent uses of the plant patent agreement, so that the product should be marked with the patent. There's royalties and fees, of course, that's the money that's coming back to the licensor. So typical in there is a percentage of net income, or is it a percentage of the gross revenue? People prefer gross revenue because it's less subject to interpretations of the cost, and a top line royalty rate provides more certainty for both sides. There's also clauses as to who should enforce the IP. Is it the licensee or is it the licensor? Who owns that right? Typically, when somebody's taking an exclusive patent, they may be interested in become the person that deals with the enforcement to keep out infringers. The license agreement should also talk about the effective termination. What happens? When does the royalty obligation end? When does the reporting obligations end, etc. The exclusivity term of the license is the largest impact on the terms. You may want to discuss upfront fees or milestones on the various steps to going to the market, and also the royalty rate. There should be also discussions of the IP cost and who pays for that or who gets reimbursed for that. You should also think about whether or not the licensee is able to sublicense, and if so, to whom, and then who enforces the patent. There should also be clauses on dispute resolutions. Is it arbitration? And if so, the specifics of that. How many arbitrators? Where is it? Under what law should apply, etc. And so the law, the forum we just discussed, where is the location of the dispute resolution, and what law should be applied. You should discuss whether or not the license is assignable, and is it assignable to the from the licensors as well as assignable from the licensee perspective. There might also be force majeure terms, such as what happens in the event of war or a major disaster that's unplanned for and that renders the entire agreement inoperable. The license should discuss remedies available to the licensor as well as the licensee in case of contract breach. You should also consider putting in disclaimers that you're uncertain about. And then last but not least, the licensee should be indemnified by improper uses of the patented technology by the licensee, for example. Let's take an example of a deal structure for Apple patent licensing. In this case, in this example, is a non-exclusive license in the US with a particular license fee and tree royalty per tree sold with an annual minimum royalty, and then trademark royalty is applicable after the patent expires. So this is a way of reaching more than the patent life. In another example for Apple varieties and trademarks, is an exclusive license in North America and worldwide, except for China, because the licensor believes that China is going to be a big market. So in that deal, the deal discussed the license fee, the royalty, the annual minimum royalty, the acreage fee for the planted trees, and also trademark royalty, which provide you with perpetual royalty rights. Patent licensing can be complex, so please visit patentpc.com for more information and help if needed. Thank you.